Chapter 9. Merger of Crimes. Section 145. Definition, use of terms. Merger, in its comprehensive sense, consists in the absorption of one right or liability into another of higher legal degree, by operation of law, where the two rights or liabilities concur in the same person. In this comprehensive sense, the term merger is applicable to contracts, estates, torts and crimes. The phrase, of higher legal degree, as used in the definition, has reference to technical legal classifications. A contract under seal is of higher degree than one resting in parole, a freehold estate is of higher degree than an estate for years, and a felony is of higher degree than a misdemeanor. The phrase, by operation of law, as used in the definition, means that merger takes place irrespective of the intention of the parties. Merger is the equivalent of confusion in the Roman law, and rights are said to be merged when the same person who is bound to pay is also entitled to receive. This is more properly called a confusion of rights, or extinguishment. Section 146. Merger of tort in felony, English rule. In the ancient common law, where the same act constituted both a tort and a felony, the former merged in the latter so that the civil remedy was extinguished. By the great weight of English authority, the tort does not merge in the felony. According to the English rule, however, the civil remedy is suspended until the criminal prosecution is terminated. The reason assigned for this rule is that it tends to incite the victim to bring on a speedy criminal prosecution. And, growing out of this rule, it has been held that the plaintiff, in the tort action, must allege and prove due diligence on his part in the criminal prosecution. This is not essential, however, where the plaintiff is not the felon's victim. The reason for this latter rule is, no duty rests upon the plaintiff in such a case to prosecute the felon criminally. Section 147. Merger of tort in felony, American rule. In this country, as in England, the tort does not emerge in the felony. In a few states, the English rule, that the civil remedy is held in abeyance until the criminal prosecution is terminated, was adopted, but in most states it was repudiated. The reason assigned for its repudiation in the latter states was, that it was not adapted to our conditions and therefore was of little or no importance. In those states which adopted it, statutes have been passed abolishing it, so that in this country today it is obsolete. Section 148. Merger of tort in felony, history of the doctrine, Judge Bigelow's view. The doctrine, that all civil remedies in favor of a party injured by a felony are, as it is said in the earlier authorities, merged in the higher offense against society and public justice, or, according to more recent cases, suspended until after the termination of a criminal prosecution against the offender, is the well-settled rule of law in England at this day, 1854, and seems to have had its origin there at a period long anterior to the settlement of this country by our English ancestors. The source, whence the doctrine took its rise in England, is well known. By the ancient common law, felony was punished by the death of the criminal, and the forfeiture of all his lands and goods to the crown. Inasmuch as an action at law against a person, whose body could not be taken in execution and whose property and effects belonged to the king, would be a useless and fruitless remedy, it was held to be merged in the public offence. Besides, no such remedy in favour of the citizens could be allowed without a direct interference with the royal prerogatives. Therefore a party injured by a felony could originally obtain no recompense out of the estate of a felon, nor even the restitution of his own property, except after a conviction of the offender. But these incidents of felony, if they ever existed in this state, were discontinued at a very early period in our colonial history. Forfeiture of lands or goods, on conviction of crime, was rarely, if ever, exacted here, and in many cases, deemed in England to be felonious and punishable with death, a much milder penalty was inflicted by our laws. Consequently the remedies, to which a party injured was entitled in cases of felony, were never introduced into our jurisprudence. Without regard, however, to the causes which originated the doctrine, it has been urged with great force and by high authority, that the rule now rests on public policy, that the interests of society require, in order to secure the effectual prosecutions of offenders by persons injured, that they should not be permitted to redress their private wrongs, until public justice has been first satisfied by the conviction of felons, that in this way a strong incentive is furnished to the individual to discharge a public duty, by bringing his private interest in aid of its performance, which would be wholly lost, if he were allowed to pursue his remedy before the prosecution and termination of a criminal proceeding. The whole system of the administration of criminal justice in England is thus made to depend very much upon the vigilance and efforts of private individuals. There is no public officer, appointed by law in each county, as in this Commonwealth, to act in behalf of the government in such cases and take charge of the prosecution, trial and conviction of offenders against the laws. It is quite obvious that, to render such a system efficacious, it is essential to use means to secure the aid and cooperation of those injured by the commission of crimes, which are not requisite with us. On the other hand, in the absence of any reasons, founded on public policy, requiring the recognition of the rule, the expediency of its adoption may well be doubted. If a party is compelled to await the determination of a criminal prosecution before he is permitted to seek his private redress, he certainly has a strong motive to stifle the prosecution and compound with the felon. Nor can it contribute to the purity of the administration of justice, or tend to promote private morality, to suffer a party to set up and maintain in a court of law a defense founded solely upon his own criminal act. The right of every citizen under our Constitution, to obtain justice promptly and without delay, requires that no one should be delayed in obtaining a remedy for a private injury, except in a case of the plainest public necessity. There being no such necessity calling for the adoption of the rule under consideration, we are of the opinion that it ought not to be engrafted into our jurisprudence. We are strengthened in this conclusion by the weight of American authority, and by the fact that in some of the states, where the rule had been established by decisions of the courts, it has been abrogated by legislative enactments. Section 149. Felony versus misdemeanor. Doctrine of merger at common law. At common law the distinctions between a felony and a misdemeanor were much greater than they are today. A misdemeanor was entitled at common law to certain privileges which were not allowed to a felon. Thus, the former was entitled to the full privilege of counsel, to a copy of the indictment against him and to a special jury, but a felon was not entitled to any of these privileges. Owing to these distinctions, a person indicted for a felony might not be convicted of a misdemeanor which formed a constituent part of the felony. His acquittal of the felony, however, was no bar to an indictment for the constituent misdemeanor. Where a person was indicted for a misdemeanor, and the proof showed that the crime committed was a felony, the court would order an acquittal, in which case, however, the defendant, subsequently, might be indicted and tried for the felony. Again, where a misdemeanor at common law was made a felony by statute, an indictment for the misdemeanor would not lie unless the misdemeanor merges. The conviction therefore being no bar to a subsequent indictment for felony, one might be punished twice for the same offense. An ample sufficient reason is that the offense has been made a felony and a felony only, and therefore an indictment as for a misdemeanor will not lie. At common law, a constituent misdemeanor merged in the felony of which it formed a part. This doctrine of merger resulted from the marked differences which existed at common law between felonies and misdemeanors, not only in extent of punishment and consequences of conviction, but also in the methods of procedure as stated above. For if a misdemeanor formed a constituent of the felony, the prisoner would lose substantial advantages of the method of trying misdemeanors. And where one was indicted for misdemeanor and proof showed a felony, he was acquitted of the misdemeanor in order to indict and try him for felony. Consequently, it has been held in both England and America that where an indictment was for a conspiracy to commit a felony, though the conspiracy would be a misdemeanor, if the object of the conspiracy was completed and a felony was committed, then the misdemeanor would merge in the felony. Bishop says, there is at common law a wide distinction between felony and misdemeanor. It affects alike the punishment, the procedure, and several rules governing the crime itself. Out of the distinction grows the doctrine that the same precise act, viewed with reference to the same consequences, cannot be both a felony and a misdemeanor, a doctrine which applies only when the identical act constitutes both offenses. Section 150. Felony versus misdemeanor. The modern doctrine common law rule abrogated. Modern legislation and judicial decisions have abrogated to a great extent the doctrine of merger as it existed at common law. The technical line of demarcation between felonies and misdemeanors still exists, but most of the distinctions which existed at common law have been swept away. In many states it is the law that a person charged with an atrocious offense may be convicted of any constituent offense of a lower degree, provided such minor offense is substantially included in the description in the indictment or accusation, and even without regard to the technical line of demarcation between felonies and misdemeanors. Bishop, after discussing the rule that a conspiracy merges in a felony, says, this doctrine, the reader perceives, is contrary to just principle. It has been rejected in England, and, though there may be states in which it is binding on the courts, it is not to be deemed general American law. At common law it has been frequently held that if a misdemeanor, e.g., assault, turns out to be a felony, e.g., robbery, then, on the ground that the misdemeanor is extinguished by being merged in the felony, the defendant must be acquitted of the felony. A more rational doctrine, however, has been established by statutes, and in some jurisdictions by common law, to the effect that the prosecution may in such cases waive the felony, and prosecute only for the constituent misdemeanor, supposing the misdemeanor be proved. According to Lord Denman, a misdemeanor which is part of a felony may be prosecuted as a misdemeanor, though the felony has been completed. and it is the opinion of Chief Justice Andrews that, upon the whole examination we are of opinion, upon principle as well as upon authority, that this conviction for a conspiracy to commit theft ought to be sustained, although the evidence by which it was proved also that the theft had been actually committed. Section 151. Crimes of equal grade do not merge. The doctrine of merger is not applicable to crimes of equal grade, even at common law. It follows, therefore, that where the two crimes are both misdemeanors, or both felonies, there is no merger. Thus where the indictment is a misdemeanor and the offense for the commission of which the conspiracy was formed is also a misdemeanor and is completed, there is no merger, and so if the conspiracy charged is a felony, and when completed the crime is a felony, there is no merger. Section 152. Rule where one act includes two or more crimes. As a general rule, where the same act includes the requisite ingredients of two or more distinct crimes, the offences are not merged, and a prosecution for one will not bar a prosecution for the other, or others. In some jurisdictions, however, the contrary doctrine obtains. In harmony with the general rule, it has been held that an acquittal or conviction under an indictment for the murder of one person will not bar an indictment for the murder of the other, where both were killed by the same act, and that an acquittal, under an indictment charging the defendant with having mixed arsenic with flour and having caused it to be administered to a certain woman with intent to kill her, is no bar to a subsequent indictment charging him with the same act in mixing the arsenic with the flour and causing it to be administered to a certain man with intent to kill him. An assault and battery committed in the presence of a court is also a contempt, and the guilty party may be punished for both offences. So, an assault and battery may constitute an ingredient of a riot, in which case the offender may be convicted of both crimes,